researcher will look at this law and then also interview and look at how this specific law is going to affect me as an ordinary citizen of Gauteng province, and then do what we call a research socio-economic impact analysis. Then we advise the committee. Once the committee has been briefed, legally advised, received a socio-economic impact analysis, then the committee will come to you. Committee will come to you with the national department so that the national department can brief you, and then you hear what is this bill about. And then we'll also have the province saying, Rina, as a provincial department, we think this bill should go through, or we do not support this bill. And then you will have what you call the stakeholders will then, after they've heard all these presentations, the stakeholders will then say, we agree or we don't agree. And then once we have received all your comments, we then sit down with the researchers and then we interpret what you would have given us. When we do submissions, we either do them orally when we are here, or you do them in writing. And then we analyze them, and then after we have analyzed them, we say, National Council of Provinces, this is what the people of Gauteng are saying. And based on what the people of Gauteng are saying, we are recommending the following. And then we translate it into a report which we call the negotiating mandate. That negotiating mandate is prepared in terms of the Mandating Procedure Act. And then we send our permanent delegate with the negotiating mandate. And then if a rejecter will say, no, we are rejecting the bill in its totality. If we are accepting it, we'll say we are accepting it. If we are saying we are accepting it with amendments, we'll say, no, we are accepting it with the following amendments being considered. And then we'll give the national department to have a look at our recommendations. If they are incorporating them, they'll incorporate them, and then they'll bring them back to the province. The committee then will sit down and say, no, have they taken into consideration what our people are saying? Yes or no? And if they have taken into consideration what our people are saying, and we are of the view or this piece of legislation is also going to be beneficial to us, the people of Gauteng, then we prepare what you call a final mandate saying we are supporting this bill, we are rejecting this bill. And then we send our permanent delegate who is going to then be representing us in the NCOP. If 5 provinces out of 9 provinces support this bill, it means this bill can go through, and then we take it back to the National Assembly to say, National Assembly, we have consulted with the 9 provinces. Out of the 9 provinces, the majority is agreeing with this bill. And then if the president is of the view all the things have been done, then they will sign and assent it into law. If there is a dispute, NCOP is agree with what Parliament is saying, then this bill will be taken for mediation, and then there will be other processes so that we are able to meet each other halfway. It is important that when we make submissions, we make relevant submissions to a bill. So meaning, or you go and look at the clauses in terms, and these people go Parliament, make life so easy for us because they also attach a memorandum to every bill, so that when it's very technical and you can't understand, you can go to the memorandum and refer to the memorandum. Now, when you see where something is not suiting you, then you say, Clause 1, I don't agree with 1, 2, and 3, so that we know exactly what you are talking about. Sometimes we have challenges. You find that people are talking about housing issues when we are dealing with a water bill or when we are dealing with another bill. And then it means that your opinion is not heard. It's important that we give input so that when we look at the laws, we are able to say, no, these laws are our laws, they are suitable for us, they are convenient for us, and we were also a part of these processes. I used to work somewhere and people would say, nothing about us without us. And that is exactly why we are here. We can't make any laws which regulate us without your input. That is why your input is very valuable to us. It is important that when we make submissions, we make relevant submissions. It's important that when you make submissions, we make relevant submissions so that these submissions are able to be translated into recommendations. Thank you very much, Honorable Chair.
Thank you. Asimshaleni izandla. Thank you. Now, we're going to go to the presentation of this bill that we're here for. And we're gonna get it from Mr. Likala, who is coming from the National Department. Yibo laba abadraftile. But we drafted because there is a concern. Asimuzwa ke ukuthi ufuna uthini kithi. Simamele so that niphethe into zokubhala. So that where you want to raise mhlambe Aisha. Yeah. Before yena, can I call Kaya Mdlalose to add on the apologies that we do have?
Thank you, Chairperson. The other apologies that we have received, I don't know if they had mentioned the MEC and the HOD. Oh, sorry. Yes, thank you, Chair. We do have an apology from the HOD, who's currently attending a continuation session of the annual operation plan bootcamp, which coincides with today's meeting. And then the department will be represented by Ms. Kanyisile Nene, the Chief Director, Property Management, as well as Ms. Cordelia Nokaga, the Chief Director, Legal Services, and the DIT support team. And then, Chair, we do have an apology from Honorable Member Mokheti, who had indicated that she's unable to attend the meeting due to another meeting that she's attending at the GPL. And then we do have an apology from Honorable Member Fuchs, who's currently out of the country on official GPL business, as well as the apology of the chairperson, who's currently on political leave until the 5th. Thank you very much, Chair. Sorry, Chair. Another one from Honorable Njokwe, who currently has a family who's attending to a personal matter at the moment. Thank you very much, Chair.
Okay, thanks very much. Can we just see those that are representing the provincial department? Just stand up. You're welcome, thank you.
Thank you, Chairperson. Honorable members of the legislature, members of the public, for giving us the opportunity to interact with you this morning on this bill. The purpose of this interaction is so that you can make a meaningful contribution about your views on this bill. I will deal with the overview of the bill at a high level. We will touch on the clauses, although I will not deal with the clauses word for word. I will just paraphrase. The starting point, perhaps, should be to indicate that the legislative policy proposed in the bill is anchored on the Constitution, which is the supreme law of the country, and which tells us that law or conduct inconsistent with it is invalid. In other words, this means that this bill must mirror the provisions of the property clause of the Constitution. the property clause, meaning section 25 of the Constitution. And when you look at section 25 of the Constitution, you will see there that it is mentioned that expropriation of property can lawfully take place when it is for a public purpose or it is in the public interest and subject to payment of just and equitable compensation. That is the most important aspect that is that controls the whole issue around expropriation. There are other principles, very important principles of the Constitution that we need to take into account before we deal with the bill itself. These aspects of the Constitution or principles relate to, for instance, the issue of equality, Section 9 of the Constitution. This is what the bill tries to express as a legislative policy. Secondly, the bill tries to infuse the just administrative action requirements in the Constitution in the bill itself. The power of expropriation is not only exercised by the National Department of Public Works at the national sphere of government. There are other public authorities across the three spheres of government in terms of their legislation within the areas of their functions, which grants them the power to expropriate. In the local sphere of government, municipalities, in terms of the relevant legislation, possess the power to expropriate. Within the provincial sphere of government, government departments and other state organs possess the power to expropriate. The same thing in the national sphere of government. Now, what this bill seeks to do is to create uniformity of procedure in terms of which all these expropriating authorities can refer to when they expropriate in terms of their relevant legislation. For instance, if the Department of Rural Development and Land Reform wants to expropriate for land reform purposes, say for instance, they want to expropriate for restitution purposes, they will use the Restitution of Land Rights Act to expropriate, but then the procedure that they will have to apply for that expropriation will be the procedure that is contained in this piece of legislation, in this bill. In other words, this bill serves as a framework legislation that serves all expropriating authorities. It is legislation similar to, it is a framework legislation similar to legislation like the Intergovernmental Relations Framework Act, which guides state institutions in respect of intergovernmental relations. Now, in terms of the overview through the clauses, clauses 1 and 2 deal with definitions and the requirement of dialogue before an expropriation can take place. I will touch on one or two definitions which are also very topical that have confused some people. Firstly, there is the definition of property. In terms of this bill, property is defined in line with the principles of the Constitution, and it is a bit wide because the Constitution casts it wide. And in the Constitution, property is defined as property is not limited to land. That is what the Constitution says, which means that sitting here, we know of certain traditional forms of property, like immovable property, movable property, and some intellectual property. However, there are other forms of properties which are constitutionally new forms of property. Some have been there, but they have now been confirmed, even by the Constitutional Court, to be property. For instance, licenses. A license to trade or to sell liquor, a liquor license, is regarded as property. Shares are also regarded as property according to judgments of the Constitutional Court. So the concept of property is very broad. Now, we have to align ourselves to the Constitution, because if we are to define it in a very narrow sense, in other words, just to say property refers only to land or buildings, we will be unduly limiting the right to property as defined in the Constitution. And by doing so, we would be falling foul of the Constitution, and it means the bill would not pass the scrutiny of the Constitution in terms of Section 36, which is the general limitation provision. So, for this bill to pass constitutional muster, it has to comply fully with the requirements of the Constitution. As I've already indicated, the other definition that is contained in the bill is the definition of public interest. Public interest is also defined very broadly. And the Constitution also defined public interest to include the nation's commitment to land reform and to reforms to bring about equitable access to South Africa's natural resources. It is deliberately that broad, and in terms of the 1975 Act, this aspect of public interest is not covered. So this bill incorporates this requirement so that issues of land reform and other public interest matters can be covered by this bill, including issues that have got to do with access to South Africa's natural resources. For instance, issues around fishing licenses and so forth. So those are just some of the definitions which are very important. Clauses 3 and 4, or before I pass on to clauses 3 and 4, clause 2, the main issue around clause 2 is the requirement that before an expropriation can take place, parties should negotiate, or there has to be dialogue around the intended expropriation between the parties affected by the proposal to expropriate. That is an overriding requirement before an expropriation can take place. Clause 3 and 4 grants the Minister of Public Works specific powers to expropriate. It is a specific power to expropriate in relation to the mandate of the Department of Public Works, which is the provision and management of accommodation, land and infrastructure needs of organs of state. Now, in respect of the National Department of Public Works, it would be accommodation, land and infrastructure needs of national government departments. In the provincial sphere, the power to expropriate would be vested in the MEC responsible for public works in respect of the provision and management of accommodation, land and infrastructure needs of provincial government departments. And then the municipality also would also expropriate in terms of their own legislation. But specifically in respect of these powers in clauses 3 and 4, the Minister of Public Works is the authority responsible for the management of the bill. Currently, he is also the executive authority responsible for the management of the Expropriation Act 63 of 1975. So when this bill is passed into law, he will be responsible for the management of this act. In other words, he will oversee the implementation of this act in respect of the procedures and so on, including even passing regulations necessary for the implementation of this bill. Clauses 5 and 6 contain the procedure that must be observed by an expropriating authority before an expropriation can take place. These processes include the process of investigation and the process of granting access to the identified property that may be a candidate of expropriation. And during the investigation phase, what takes place there is a needs assessment. In other words, the qualities of the property or the characteristics of the property are looked into by professionals like valuers and estate agents and other property practitioners, so that they can authoritatively be able to attach value to the affected property. In the event that the affected property that is a candidate of expropriation is perhaps state land or property that belongs to the state, in respect of land reform purposes, there is the Office of the Valuer General, which will be responsible for attaching value or assessing the characteristics of that kind of property. And that kind of assessment would also assist in the determination of the correct form of compensation. Clauses 7 to 11 deals with two types of notices. The first being the notice of intention to expropriate, and the second being the notice to expropriate. Now, in terms of the notice of intention to expropriate, it is the first step where the expropriating authority makes the owner of the property aware that it intends to acquire the property either for a particular public purpose or a particular public interest. Now, in that notice, the affected person would be informed about the identification of the property, the purpose for which the expropriation is being proposed, and the time frames that would happen. The person who would be affected would also be given an opportunity to either accept the offer, object to the offer, or request more information if the information that is presented at that particular moment is not sufficient. After that step, then there would be the notice to expropriate, which is the real expropriation now. When the notice to expropriate is served, the implication is that ownership at that moment passes from the owner of the property to the expropriating authority. In other words, the expropriating authority becomes the new owner. There is no need that the expropriating authority at that point should produce proof that now the property has been registered in the deeds office. That is a step that will follow much later. In other words, the expropriating authority takes control of the property as owner. But the parties can agree that the expropriated person or owner remains in possession of the property until a date that would be specified between the two parties. So, in other words, in that event, ownership and possession would be separated. But there are other cases where ownership and possession can pass at the same time. During the service of the notice to expropriate, the necessary documents must be provided to the owner so that he is aware of the issues that are being raised, and so that they can protect their rights. They have to be given the notice so that they can know what the date of expropriation is and the amount of compensation, the extent of the property that is being expropriated, and in that regard, a survey diagram or sketch plan will be provided, and an indication as to who other persons who may have rights to the property would also be indicated. Clauses 12 to 18 deals with aspects of compensation in the bill. The major clause that deals with compensation in these provisions is clause 12. Clause 12 also is anchored on the compensation provision in the Constitution. And as we all know, the requirements that are set in the Constitution is that just and equitable compensation should include the determination, or should take into account factors such as the current use of the property, the history of the acquisition and use of the property, the market value of the property, the extent of direct state investment and subsidy in the acquisition and beneficial capital improvements of the property, and the purpose of the expropriation. But these are not the only elements that must be considered, because the Constitution also says all other relevant factors must be taken into account. So this is also very broad, meaning that each case, whenever compensation has to be paid, each case will be treated on its own merits. It will be dealt with on a case-by-case basis. It will not be one size fits all or a blanket approach. Now there is a clause 12.3 which has now been included in the bill. Clause 12.3 deals with circumstances under which it may be just and equitable to pay compensation at nil. And we should understand each other here. The clause is not saying without compensation. It says nil compensation, because there's a difference between nil compensation, when you pay nil compensation, and when you say a clause without compensation. Initially, there was a proposal to use without compensation, and we were advised by the Office of the State Law Office of the Chief State Law Advisor that no, when you use without compensation, it would be unconstitutional, because when you say without, from the very beginning, you don't pay compensation. But when you say nil, you consider all the factors that are relevant, including market value. But at the end, you may come at zero. So, which means compensation would be between a range of 0 to 1 trillion. When you take this clause 3 into account. So it could be very helpful if we could understand the difference that I've just indicated very well, so that we don't create or send out a wrong message. And other clauses, as I've indicated, compensation provisions are covered from clause 12 to 18. Other provisions deal with issues around the payment of interest in clause 13. And clause 14 also, where other persons come later to claim compensation, and where people are given an opportunity to also agree or reject compensation and so forth. And clause 16 deals with rights of others, a specific group or specific category of rights holders, which are mortgagees. Maybe the property affected may be subject to a mortgage, and in that case, the rights of the mortgagee to be paid what is due to them from the compensation that has been determined would be considered, including situations where, when an expropriation takes place, the property would be subject to a sale, and there is a deed of sale already in place. In that event, that situation would be taken into account. In clause 18, the important point to make there is that where there are disputes, when when compensation would go to the master of the High Court for for safekeeping, for lack of better words. It would be deposited with the master of the High Court so that when the dispute is settled, the money can be accessed and so forth. Or sometimes it would be deposited with the master of the High Court where, you know, persons with interest to the property have not all of them been identified, and it is expected that there could be other persons who come forward to claim compensation because they have interest in that property. Clause 19 deals with mediation or referral to court where there are still disputes. And this practically gives effect to Section 34 of the Constitution in terms of providing access to courts. However, it should be noted that even when there is a dispute around compensation, the decision to expropriate is not suspended. The notice that has been served, the notice to expropriate, which has been served, will not be suspended. An expropriation remains valid. In other words, it is possible that an expropriation can take place, but the aspect of compensation is not yet settled. That aspect can still be settled in court, and that is still taking place even currently under the 1975 Act. You still have situations where the dispute is only in relation to compensation and not the reason or purpose of the expropriation. So in such instances, the expropriation will proceed. Clause 20 deals with agent expropriation, and the nature of agent expropriations is that they are temporary and they may not exceed 12 months. And in the event that a temporary expropriation or an agent expropriation exceeds 12 months, it would be on the basis of a request made to extend that period. That provision is covered in clause 25, which provides for extensions of time, but it would not be in total a period that exceeds a maximum of 18 months. And even in that event, just an equitable compensation must still be paid, and agent expropriations will take place in situations identified or covered by the Disaster Management Act or following an order of court. Clause 21 of the bill makes it possible for an expropriating authority to withdraw an expropriation. And this can be done if that expropriation is in the public interest or the reason for which the property was expropriated is no longer applicable. However, the bill does not allow an expropriation to be withdrawn where 3 months has already expired since an expropriation took place, or where the property has already been registered in the deeds office, unless the parties or the affected parties agree that that can be done or such a situation can be reversed. Then the expropriation will be withdrawn. Clauses 22, 23 are just standard clauses, However, we should note clause 24, which is an innovation in the bill, which requires the Minister of Public Works to keep a register of all expropriations, and such a register will be a public document. Members of the public will be granted access to it. And this will enable members of the public to know how many expropriations took place within what period of time, in which areas, and in which type of land use, for instance, and so forth. So it would be some kind of a document that would also make it possible for the state to improve its decision-making capabilities and information sharing across the three spheres of government. And as we all know, legislation is law. So if you violate law in South Africa, because in terms of our constitution, the rule of law applies in this country. It is one of the values of our constitution. So if you violate this bill when, or law when it is passed into law by Parliament, you would be subjected to sanctions, and sanctions would take the form of either you being criminally charged, or you may be fined in a civil manner. And finally, clause 27 makes it possible that if there are administrative errors of a non-material nature and where the affected person is not prejudiced, such mistakes can be corrected. And this is a normal thing to do because if it is not included in the bill, there could be very costly repercussions for government, even where there are just minor administrative mistakes, if this clause is not included. This makes it possible that non-material mistakes where no one is prejudiced, and say, for instance, you've been served with a notice of expropriation, and maybe your name has not been spelled correctly, or there is some minor information that has not been captured correctly. That mistake can be corrected, and the expropriation will remain valid. And the final point to make, which I think is an oversight on my part, is to indicate that expropriation is a power which only the state can use. No private person can use the power of expropriation. No private person can say to another person, now I'm expropriating you. It is only the state that can expropriate. In one of the public hearings, there were persons who were saying, actually, this bill represents a direct, just to quote that person, saying it represents a direct attack on private property rights. And I think it is an incorrect observation, because if you are to look at clause 25, section 25 of the Constitution, if you allow me, Chair, I'll quickly just read that section. Section 25(1) of the Constitution says, no one may be deprived of property except in terms of law of general application, and no law may permit arbitrary deprivation of property. And that provision is what is normally referred to as the property guarantee. So every person is guaranteed property rights in terms of the South African Constitution, which means an expropriation which only the state, the power to expropriate, which only the state can use, is an exception to that general rule. And it will only be used in only particular circumstances, which circumstances are if it is for a public purpose or for a public interest. In other words, there is no way that the state can expropriate property so that that property can be used for the private interests of members of parliament. That would not be a public purpose or in the public interest. You have seen what the definition of public interest says. And public purpose, as we all know, public purpose includes where the government, in the normal course of it performing its functions, provide public services and public goods to the citizens or to the population in terms of legislation, different types of legislation. For instance, health services.
I think this is how it's going to happen. The first speaker, please introduce yourself first and speak on the bill. Thank you.
Hello, my name is Mishak Junior Ntani. I come from Winterfeld, 10 Morgan. Actually, I've been sent here by the Farmers Association here to come and make and observe, and after that make a presentation. I'm glad when one of the speakers spoke here, made a distinction between what I thought will be the hearing. I thought we are here to deal with Section 25 of the Constitution that deals with, land, expropriation without compensation. I'm glad we have really assisted us that here we are only dealing with the issue of expropriation. And this expropriation, if ever I was listening very well, it is going to be, it is going to provide that framework that will deal with different types of land, mechanisms that we want to take in order to deal with the issue of land redistribution and restitution in this country. So, in general, or in principle, we do agree with the expropriation, bill. It is a correct piece of legislation if ever it is going to be passed by the president. It is long overdue. People are suffering in this country. There is a tendency to want to take advantage of the legal process in order to hinder the process of land redistribution in this country. And we hope that as lawmakers, you will ensure that at least this process become expedited. Firstly, we have seen efforts when it comes to land, distribution in this country, where people go into legalities and all the stuff and everything. And some of you have heard you speaking there. You are lawyers, you know the cost of litigation is quite exorbitant in this country. And to a certain extent, the Constitution has been utilized as a playground to stop transformation in this country. We are glad that we have inserted a provision that deals with the issue of nil compensation. And we know that, there is going to be a clash because of when you look at Section 25, it says there must be just and equitable, compensation. And unfortunately, the government must bear responsibility here just because of 30 years after attaining democracy here. We don't even have a single case where the government has expropriated land and there is a dispute or a disagreement. That agreement is escalated to the level of the Constitutional Court so that it should be able to assist us that what is the true meaning of this just and equitable compensation. If ever the government took initiative to expedite the issue of land redistribution and restitution in this country, we wouldn't be sitting here with this concept called nil compensation. But we do support the process. We say that the bill is overdue. We hope that it will help us in dealing with the issue of land redistribution in this country.
Good morning, I'm Adams van Sail. I'm here from AfriForum representing our 310,000 members nationwide and specifically our 115,000 members in the province of Gauteng. Unfortunately, I'm struggling with reading my notes here within this government-induced energy crisis that we are currently facing, but I will do my best. This expropriation bill, you asked that we have to state whether we support or do not support it, and we absolutely reject it on many grounds. The expropriation bill should not pass because it will cause economic devastation, contribute to a food security crisis, and enable human rights abuses. Furthermore, various sections of the bill are unconstitutional and can and will be challenged in the courts and very likely successfully. If this bill were to become law, it will deprive citizens of their constitutional right to private property. We can debate around these little details, but the devil is in the details. And when it comes to the details of this bill, it will deprive citizens of their constitutional right to private property. The destruction of the right to private property through this bill will have a very negative effect on foreign and domestic investment and job creation. The bill's purpose cannot be construed as to right the wrongs of the past because all it enables is further wrongs to be committed in the present. AfriForum, and in this context our Gauteng members specifically, demand that this bill not be passed and that the right to private property in this country be protected and not destroyed. The existing land restitution process has been derailed by corruption, political greed, and mismanagement. The problem is not the willing buyer, willing seller model. The problem is that the government has proven itself to be an unwilling distributor of the land that it has hoarded for 3 decades. The government owns approximately 17 million hectares of land. That is the surface area of the provinces of KwaZulu-Natal and Mpumalanga combined. Can the government prove that it can redistribute some of the land that it already owns? Its track record says absolutely not. Redistributing land to cadres or the politically connected does not count. Therefore, we would like to see redistribution of land that the government already owns in practice first, before the government is any conversation about giving the government power to expropriate or hoard more land. Due to the failures of the government and rampant corruption, South Africa is currently experiencing an electricity crisis, an unemployment crisis, a crime crisis, and an open borders crisis. The expropriation bill will only add fuel to this fire, and that is a guarantee. The expropriation without compensation, or in this case now through technicalities, nil compensation, is state-sanctioned theft, deeply immoral, and a human rights violation. It is an inhumane policy motivated by a combination of corrupt greed, cynical electioneering. It's not a coincidence that we are heading into an election year next year now that this is now again on the table, and also it is motivated by resentment. The ANC are gearing up to violate the rights of millions of South Africans and cause an economic disaster, and therefore the resistance to this bill is growing, and there will be a fight to protect private property rights in this country. Ke a leboga.
Dumelang. Lebitso la ka ke nna Mpho Matlhabane. I just want to, Mabone, it's difficult. I've written notes here. Now it's difficult to even read my own notes. Load shedding. The first thing, I want us to deal with issue of property laws, section 25. I think I must give it context because it's the one that guarantees the right to property. So I think it's important that we must start there. Thank you very much, ma'am. I don't know whether I think we must start there. The irony around the guarantee of a property clause is that, one, it guarantees property that was acquired illegally. That's where we must start. The legal department of Parliament and NCOP. The property clause guarantees the right to property, the property that was acquired illegally. You must remember that in whether it's 1913 or 1652 or the Ordinance 50 or 1937 Administration Act, black people were not allowed to own property. It was only white people. That is why AfriForum is here with their 3,000 members saying that we must not allow this bill. It's precisely because they acquired land and property illegally. And then we took the constitution and legalized that acquisition, which of course you would remember the Nabatuba government, that is the sunset clause, that has created this problem for us. So we have got a difficulty with that part because the irony around that property clause section. Now, the clause 12 that we have just dealt with, that deal with circumstances, the just and equitable. We agree with the expropriation, but our view is that it must be without compensation. We must not deal with nil and all that, so that we can accommodate the investors and all those things. Our people need their land, and we need to expropriate for equal distribution. And that's what we believe, that if it is expropriated for equal distribution, it will bring total liberation to our people. That is why we supported this bill. And lastly, this is difficult. I think I must leave it there, that we support it. We just have a difficulty with clause 12.3 that deals with the nil. Right now, our position is that it must be without compensation. Thank you very much. Thank you.
Thobela khotsu nna lebitso la ka ke nna Butinyana ke nna Deriko a Mosito. Unfortunately, ke se bo ngwala, that's why nna ke sa tshwara dipampiri tse ba di tshwereng gore ke kgone go bala. E fela re ke thome ka go amogela bagolo ba rena mo from legislature. Ke leboge le badiredi puso ka ene ba tlhalosa ba re tlhalosetsa botlhokwa ba molao. Ke fetse ke re Ke tla ke le ke nna ke kemedi from Winterfeld PCO. Ke fetse ke re o bona molawana o nna e le nna botinyana ko nesetsa pula ke ra o amogelwe ebile ke bolela ka pelo e botlhoko gore ke kwele ba boletse o bona bo AfriForum ba ka mokgwa ba boletseng ka gona ka gongwe ne nka dumelana le bona ge e le gore a go nna le botsotsinyana ko morago tseba go na le ntho engwe ba e bolelang ebile ke re ke bolele sa ešo se go na le ntho engwe ba e bolelang pele ne ba e bolela ba re taba tsa maburu di a patwa tsa rena di a pepetswa so ntho ke masawana ke thoma ke bia ona mo sentle ke bolele re why o bona nako ele e fitileng ka re before or after 1994 Saloga fia minitoria. And minitoria e file nyele go file area ene e tshwere e bontsha e tshwere bopaki ba ownership ya di properties. So bopaki bo bo sweletse benang AfriForum e tlo re botsa mo ka private property right. Ne ke kopela ne ke kopile last time mo di public participation tse di fitileng ke ile ka kopa gore some belief a le rena taba tsa rena tsa bona di iswe go ntho a go appoint a commission of inquiry re nyakise re butswa ga botse gore ke dipampiri tse di feng tse di fititsweng ka gore pele le nna bekele ka mo counseling ke ile ka gopela audit ya ownership ya most of the properties a ona lo moana o ilatla ka proof ya bontsha property tse ke tsa rena ke yaka especially di plus biale be ke gopela ibile ke khuname ka letolo mo fase ke re wena morwedi or morwedi or makekana le warra ke gopela le re thushe mo thuso lena re gopela e tseneletseng gore re khona o itse go rarolla bothata bo ga botse ntho ngwa bobedi re kgopelang mo departmenteng a re le kono be ka masuika mare be re le kgopela gore go sasa he go tla especially technical issues tse le di raisitseng tse re kgopela gore go nne le ntwele le introduce ntwele ba ibitsang consumer education e botlhokwa gore ba baagi ba le bona ba khona go tseba ba kwisha botse gore a botse le bolela ka eng ka re ntwe ngwe ke botsa o ntatong khodishijo ke mmutsore na re ba bolela ka nnili le ba bolela ka without compensation bothata nna ke bona botse mo re there's a thin line there so it must be clearly or thoroughly explained biale ke boela morago ke re nna molawana o khalo re emetse bila o phetagale ke a leboga
Morning, Chairperson and your entourage, or good day. Nkosi is my surname from Winterfeld. Sanbonani Bahlal. In terms of the bill, the previous speaker has already acknowledged the position of the people of Winterfeld. Now, the only problem I have is that in Winterfeld is owned by landlords. Now, what is happening now, these landlords, they are selling pieces of their stands to the people who come from outside. Now, as members of the community, we do not have any say to these particular individuals. Now, how this particular bill is going to be applied, we'll see it then. But to the legislature, what I'm trying to say is that if this issue is not being attended seriously and very quickly, trouble is going to be coming up in Winterveld between the communities and the people who are coming from outside. That is where I'm going to end up in terms of this bill. Secondly, Chair, on the 14th of March this year, your office was in Mamelodi. We were invited and we attended. The issue of Winterveld was never addressed, and we requested that the legislature should please come to Winterveld and come and address us. My family arrived in Winterveld in 1964. They were removed from Constantia Park, just under Moreleta Park in Pretoria. Even today, that area is the same as it was in 1964. So we will really appreciate that the Premier's Office, Human Settlement, must visit that area to come and tell us what is going to happen. It's still an informal settlement. Even now, I think I'm going to die and it will be still an informal settlement. I thank you.
Hey, Dumela. My name is Dipolelo Ramokopa. I'm from Denville. Actually, I'm just speaking as a citizen myself. Firstly, let me welcome the presentations from various speakers and welcome our provincial legislature representatives. Mine is going to be simple. This bill itself, I'm going to start by saying I reject it outrightly. It doesn't assist. This is why. This bill cannot be workable or implementable if it's not preceded by the amendment to the constitutional clause 25 of the Constitution. Why am I saying this? The representative from government, correctly, you're correct, representative of Public Works. This bill must be anchored on the Constitution, and it must mirror the Constitution. The Constitution that had been problematic from the beginning. The reason why we are gathered here, and this bill is supposed to be enacted, is because the Constitution has failed us in terms of land reform. So now, if this bill is going to be subjected to the very same Constitution that could not assist us in terms of land restitution, land redistribution, and land tenure, then we are just wasting taxpayers' money by this bill. This bill must be parked. We amend the Constitution. We speak in definite terms, in terms of redistribution the land and expropriate them without compensation. There is no need for compensation. This land that is being guaranteed here is land that was acquired illegally. In fact, the gentleman from AfriForum is correct to say this bill is a contravention of the Constitution in its entirety. That means we need to change the Constitution before we can enact this bill. This bill is not going to assist us, and here standing myself, I'm even asking myself, how are we going to even, what constitutes just an equitable compensation? I don't even understand. That is going to be subjected to many interpretations, and those interpretations ultimately are going to be dealt with at the level of the court. And you can imagine the length that is going to take for the courts to conclude on these matters. It's going to take long, and there is land hunger. The reason why we want to redistribute the land is because there is land hunger out there. And we have already seen the mushrooming of a land invasion. The land invasion is because it emanates from the desperation of our people who are dispossessed, and they still need to want to have land even themselves. They cannot get any simply because of these lengthy processes. Legal instruments in this country have been abused in order to delay the process of land reform. And therefore, this bill in itself is not going to assist. It's just a waste of taxpayers' money if it's not preceded by the constitutional amendment that is required in order for us to speak in definite terms, in order for government to actually do what it's supposed to do. Thank you very much.
Ke rata pele ke re dumelang bahahetso wa eme mo ke mme Maluate go tswa ko Mabopane. Ke na le sello se se utlwisang botlhoko. Ke na le sello se se utlwisang botlhoko. A ke khole hore taba e re itletse mo e ka phethagala. Because batho ba ba nang le ditšhelete ka be ke hopole ka nako engwe he ba re tse di otileng di tla ja tse nonneng di tla ja tse di otileng. Because ha o tshwana le nna o sa ruteha o no tseelwa dilo. Nna ke mme wa tlhokometseng bana from 1975 ba di khutsana. Ka ba le pleka ya mathomo ko Hantate Ngobeni ko Winterfeld e rekileng ke ma-America. Le khua ka hore le na le tšhelete a tla a re ke tlo go thusa. Ha re ke tlo go thusa bofelong o tsere pleke ela o e rana ka ya bana mara title deed ke Good Hope Community Organization. Mara ka hore ke sena matla wa bereka mmeola wa bereka for mpusetsa pleke eo. Ntate Mseneke wa lawyer an rekela pleke mo mme Malele. Han reketse pleke ke dula le bana moho he ke ntse le bana moho morago he ke re ke batla title deed ha iyo ba re awa o tshwanetse o lise pleke ka gore government na setse a rile o tlo aga di RDP. Ke rekile pleke la ka 50,000 mara le ka tseno ke na dipampiri. Ha re khone o kry-a dipampiri tsa gore he plekere mara nna dipampiri tsotlhe le gore ke rekile ka mo tlasa di-lawyer tsa government ke di tshwere mara ha gona tswele pele. Gone beno Maloba ba rile he nyaka motho a tlo ba ira pleke ya hao motho a re ke nyaka 26,000 re ntshitse 26,000 eo ra mofa. Ha ke fetsa ho mofa 26,000 bona ba o tlo meta pleke ko Tshwane ko Soshangube ba re hore o kry dipampiri re batla 10,600 ya masepala ke ntshitse ke ba file mara go fitla le ka tseno a go utlwa ha le selo. Re na le bothata rena batho ba re sa rutehang re jiwa ke batho ba ba rutehileng. Batho ba le ba ba tsereng pleke ya ka mathomo ke di-lawyer monna le mosadi ke di-advocate. Nna ke tla ikira ka tšhelete ya di-advocate a ke na yona. Ha o ya ko governmenteng le yona ya o duba ko re dilo tsa rena ha di na bonnete. Ne re le ko Mamelodi bena ka ntate o nna bolela last rena pleke ya rena a re a ya bolelwa. Gona bjanong ha o ya ko di-officing Loate go na le Loate wa LOATE o mongwe ke LW dipampiri tsa ka di tshwane. Ha o ya ka mo ha se sona sefane se ha o ya ka mo o leka go ya ko bona gore nthuseng le lebelle dilo tsotlhe gore di tsamaya bjang. A gona motho a ka o thusang. Batho ba ntse mo ditilong go ja fela a gona selo se ba ka re thusang ka sone a se teng. Le gona ka tseno he re tlile mo re tlile fela gore batho ba bereke ba gole ba khona go bona gore ba biditse batho re a tshwantshiwa gore batho ba ba kry maemo a gore ba biditse batho mara thuso yona ntho ha iyo ha iteng. A ka reka stene sa kwa Molele ka fa motho tšhelete e ne e le di-lawyer tsa e leng di ka matlasa government ra patela 50,000 eo re e fileng ke Judge Mseneke
Le ka tseno, ha rena dipampiri, o tla di tseya kae? Ho setse hore ba e tseye hape beke masepala ore, ya, o tla e leasa for 9 years, 8 months, pleke o patele hape. Mo e le horeng ke rekile stena khethe, batho ba fiwa ditene ba di kereke. Nna ke tlhokomelang bana, nna a ke praise a ke mo wa batlang ho itse ka na Google. Ya, umpatle mo Mama Mary, e tla be e o botsa loate, o bale ka nna hore how many years ke bereka ka bana, ke hodisitse bana le basadi, ke di doctor, ke di lawyer, ke eng, ke ntse mo di master. Ho sena motho wa nthusang wa government. A teng lo o mo one, lo ka ya ko bona ba nyaka tšhelete. Beno nna ke tla etsa ka tšhelete ka gore mereko wa bana a se tšhelete. Ke ntho e Modimo a o anointileng gore o ire. Nna Winterfeld ke bolokile ditšhaba le Ponkana. Ke sena tšhelete, ke tsa tšhelete ka ke patella le batho ba ba senang ko ba bolokiwang. O teng Jane Ashul. Ke bila Woman of the Year ya mathomo ya SABC2. Ka ba Woman of the Year ya Shoprite Checkout. Ka ba Mama Africa ka mo tlasa Clover. Ka ba Dr. Mary Luate, ka ba professor ka mereko nna ko ira. Mo lefatsheng o ko fileng ke Modimo. Mara ke na thuso. Thank you. Ke nna Mama Mary Luate, project ya ka ke Good Hope Community Organization. Ibile hona banong he ke bolela so, ba sutisitse bana ka gore batho ba mbatlile mola ba tlo nkahela building e kholo kanta e mo planning ba re ba donate. Yaanong ba re no, a re fokotseng bana ka gore bana ba tla wela ke building e eng. Hona banong ke no lema, ke ruta bana go bake, go ruka, go lema, go ira di blompoto, go ira di faha out of molao ka re a ke sa itse gore ke ire. Ha ona puso e tlo re thusang a iteng, re lapile le gore a ke bone ke na le 84 years gona bjanong ke ntse ke sokola le bana a gona motho a ka o thusang sa hao gore fela ba o feleletse ba go epela a gona motho a tla re thusang.
Indeed, we are grateful for the participation on the side. Now we are coming on this side. By a show of hands, please.
Number 7, yeah. What? No, what? Kiole mumra.
Thank you. The same procedure. Firstly, introduce yourself, and you are allowed to only speak for 5 minutes as we proceed. Thank you.
Thank you. Erike Thome ka o le dumedisa. Ka lebitso ke Desire Mathebe from the Economic Freedom Fighters. I want to make my submission that the Section 25 of the Constitution should be amended to allow the expropriation of land without compensation. When these white settlers took the land from our forefathers, they did not conduct public hearings, nor proper consultation, and they did not recognize our forefathers as human beings. To them, they appeared as animals. So if buying stolen goods is a crime, why do we continue to buy land? The struggle for expropriation of land without compensation is long overdue and should be speeded up. I submit.
Sorry, just a minute. Mama, ungahlala phansi ukhulume uhleli phansi. Siyabona.
Nna ke nna Mmita Motolometsi. Ke tswa ke le ko Mamelodi. Original ke tha ke le ko Lady Salbone. Re ile Mamelodi ka forced removal. Ba re gapelletsa maburu ba re betha. Ba ebile ba re tsebisa ba ne ka meeting wa ka tsheko ro no wela. Wa utlwisisa ba no re rwala ka di lorry tsa masole bo re latlhela ko Mamelodi ba bang ba ya Atteridgeville ba bang ba ya Rankuwa bianong ka tsheko maburu a tlo bolela se bona ba se ratang e le re ke bona ba ba re tlusitseng dintlu tsa rena tse kgolo di kae le di garage ba tlo re botsa ka land eo bo rakgolo rena ba e rekile nna ke tshwere title deed ba e fokoditse title deed ela nele 10,000 square meters ka tsheko ba e fokoditse to 991 feet wa utlwisisa bjano re nyako itse re remainder e nngwe eo e ya kae ene ntlu ene ba di agile a ba re patela nna ke lwile gore be ke kry title deed ka tsheko ba tlile mo ba tlo bolela nonsense a re ba nyake next le lena le ba setse morao a ke tlo le ba tsaletse morao batho ba ba re gobaditse ka tsheko re di gole ba re betha ba dira metlholotlholo ba no manyaka lefatshe le boele ko bona ba nyaka lena ba tsotho le ba joine le ba thuse ntwa e lena re lweleng okay nonsense a ke utlwisisi mo nna sorry na molao o phase re nyaka ntate Ramaphosa atle a tlo re botsa pila gore dintlu tsa rena tse ne di agilwe ko Lady Salbone ene dijarata tsa rena ne le tse kgolo gona ba no ba di fokoditse ba famang phisi e nngwe nna yaka ke nyaka e le e yotlhe ka mokgwa e bolelang constitution wa utlwisisa title deed yaka ka mokgwa e bolelang ka teng ke nyaka ile ka teng bona ba agra forum nyane eo ya teng ke bona ba ba fokoditseng so nna ke nyaka ile e yotlhe ntate Ramaphosa atle ka morena a tlo re botsa pila ene meeting o e ska ba wa di last ba nyaka gore bona ba berekile no ba ira follow up re nyaka follow up ene bolengwale mo ntlo tsa rena tse di thubilweng ne le di big house tse kgolo ba thube ntlo ya first brick ya 8-room house a re kry selo le di boys room le di garage a ro kry re kry eo nna ke tse 240,000 for pleke e kgolo bjane aowa a bereke bjano nna ke nyaka tšhelete di-million bona ba e rekisa ka di-million le nna ke nyaka di-million plus le ntlo e leng teng mo bosesi le re bitseng gape and o botsa Ramaphosa gore rena re nyaka compensation ya dintlo tse ba di thubileng and you must come back to us o tlo re botsa gore go iragalang tseo ke nonsense o ba burwa tshwantsha tsamaye le ska tlhele ba voutela man re gobetse maoto a mabedi ka tsheko re di gole tshedi nna nka se tlwele ANC a ke re bana ba re ke agriforum nna ke le ANC 84 years ke joinile ANC in 1954 and still ona ba ke veteran ya ANC a ke shutise ke tselo ke tsala pele nna tsa se
Greetings everyone. Dumelang kaofela. O eme mo pele mo ke Dorothy Mudiegi Singo from Kososhanguve Hall 36 ke branch secretary. Ke eme mona ke tswa ko Economic Freedom Fighter. Ke ema ke utlwa botlhoko ke utlwa batswadi ba rena ba lla because ntho e nkutlwisang botlhoko thata ho boletse mama Mekila Mathomo ho bolela hape le mama ene ke batho ba holo a se bo mama rena ke bo kokwa rena so ho tlwisa botlhoko o utlwe gore bo mama le bo kokwa rena ba lla ka mokhosello se ba llang ka sona is very painful. I wish gore government e utlwe le batho ba bo rena botlhoko. Now from EFF ke le Dorothy kere I want to submission that the section 25 of the Constitution to be amended to allow expropriation land without compensation. As it is an EFF #1 pillar, #1 in a 7 cardinal pillars. I thank you.
Dumelang ba bohle. Nna ka lebitso ke nna Caroline Mathibe. Ke tswa ke le ko Ward 21 chairperson ya branch. Nna ke rejecta molao because nna ha ke lebelletse especially di property le di land ra utlwa bo marena ba lla yes ba lla ke nnete. But now my problem is one. Bo marena ba lla so molao o amendiwileng o amendiwa because of o sokodisa the poor of the poorest. How favor the poor of the poorest. The poor of the poorest always see batopatsa o jafat. A person wa tloha o grepa a land. Ha fetsa o grepa the land wa thoma o rekisa that land. O rekisetsa the poor of the poorest ka 2,500 in his or her pocket. Then how's na chelete, where are you going to stay? Onna ko kae? O sna chelete. And the other thing, if you look at our people, by Longori, yes, by grepile that land. Lebella di plastic view. But ba pitla ha ni kore ha hona space. Aba hemi. Those people aba hemi. Hey, come next door, officially. Ho fia bana ba botlhe ka boshutswa ntse bana ba yo sekolong a bana diaparo a bana selo. Government ho ibitsa o re etlange batho a ba sana diaparo a ba sana selo. Ba tla ka dipanto kinyana dilonyana tse di sa reng sepe. You cannot get your ke ntlo ntlisetsa grocery ko e ja o fitlhaneng. O ntlisetsa grocery 350. Ki ranka 350. Everything is expensive right now. But the salary is not going up. Then what are we saying? And say, no, the bill is right. I pass. It pass abiyang. So, Nagele Caroline Mathibe, I reject. Thank you.
Dumela. My name is Tabiso Maloisane. We clearly reject this bill since we know that there are many factors that will affect us. Yes, I know, ladies and gentlemen, that there isn't that excitement of us marching or grabbing things that don't belong to us. We all understand our history, where we come from as a country. We understand that and we lived to that. So we mustn't be getting excited by the violence that is posed on us, because I'll make you an example with what is happening in other countries. This bill was passed by other countries such as Zimbabwe and Venezuela, where an expropriation bill without compensation or with compensation but did not satisfy the people. What is happening in those countries? The economy will never recover, and we can witness that even ourselves. So we must also consider the factors that the psychological factors that will have to affect those who have to give up their land. So the things like relocation. We are looking at the job losses here. We are looking at what we call the food security. My heart was break in 2016 when I saw a video from Zimbabwe. It was a documentary. This child, she was saying that my father was working in the farm just next to us here where we were working, where they were staying. This child, she was hunting for the reds. So that my father was working there, we had food, we had everything. Unfortunately, the farm is no longer there and there's nothing that we can do. So, ladies and gentlemen, when we support such bills, we have to consider where we're going, where we're coming from. I heard one of the speakers spoke about a voter, consumer education. I would say let's first start with a voter education. A voter education, that is where that we are going to awakening our gogos and educate them and everybody that you cannot for 5 consecutive seasons vote for somebody who comes to you and give you a t-shirt on the day of voting. Things like that.
Hello. We're not campaigning. Talk to the bill.
Yes.
Talk to the bill.
Thanks a lot.
And then, not
but I
denounce
had
an organization because
Yes.
this is a bill. Don't go to politics.
Okay, I heard also the lady from EFF was talking about the EFF and stuff, and then even with the EANC. But however, it's fine. It's fine. Thanks. So, ladies and gentlemen, let's consider a future of our children. Let's consider that what are we going to do in future, because this especially it will affect mostly the land, and land, that is where we get our food. That is where we get our meat and all those things. So in this regard, I would say we totally reject this bill, and we must make sure that we get the right people to get it done for us. Thank you very much.
Dumelang. Greetings to everyone. Chairperson, ke dumedisa batho ba botlhe. Lebitso la ka ke nna Kate Lebogang Msiza. I come from Soshanguve. I am here standing and speaking mostly on behalf of Babatla Ophelang in the future. I say today I do not support this bill. Why? Because I don't want to see what is happening in Zimbabwe to happen in South Africa in a later stage, Mobopilong. This government wants to just take and take and take from us. In terms of giving, they will give you 350. And then for the whole family, on that. What are you going to do at 350? At least when you have a land, you can plant something and go and sell and make a living for the whole family. So we are pleading that please, let people do what they want to do with their land. Do not take the land from people. Thank you.
Ashelekai, Shadrach from Soshanguve. My only worry when it comes to the bill, we can accept, we can reject. But the problem, going back, we were, whatever that is, it is written, our government was following. They do things behind the scene. Like for instance, on our presentation, Okotile clause 25, section 1, but it wasn't on the screen. And in that section, it's an important section. That naturally on a screening, I insist so that if we want to write notes, we can write notes. Ne? Okay, fine. So the only challenge ke believe bar compensate on each and every land. There was a stage whereby our government, go Winterfeld. I have a friend go Winterfeld. We did follow the court go Winterfeld. They grabbed the land by erected the RDP. That man, that family, they the livestock. So, the livestock, hona le mo this bill hona le clause e bolelang hore they will go ba kreye a beneficiary and then ba negotiate le beneficiary ba mo fe selling sa hae. But it was different on that land. Ba fitle pele ba tsa a land ba erecta di RDPs for public hore ba benefit. But ba lebelletse hore that is not their land. Why they didn't find the beneficiary first and negotiate? And then if he agrees to say yes, le kana la erecta di RDP la di erect. So when they just go there and erected that RDPs without compensating that person. I'm worried get 3-4 baba Cotileng Winterfeld. Of which go Winterfeld, it's not all about the color. It's about the government. If the request or no, we need to be compensated, please compensate them.
Dumela. Lebitso la ka ke nna Marcelo Magdalene from Atteridgeville. Chairperson, my concern is one. The clause, 12.3, the compensation. Nil. What is nil? Nil, it can be nil per os, or it can be whatever. Nil, it's nothing, it's zero. To me, it's zero. So let them go and review this particular clause. We are not happy about it. And also the other thing that I want to emphasize, we are here to come and endorse the things that we can't even support. We've got a reason why. They bring the bill to us to go and scrutinize it, read it quickly, whatever. Some of our people that are come from the rural areas, like batho ba tlhagang ko Mpumalanga, li ba re ke ko kae, batho ba tlhagang ba le ko bo Dennilton, whatever, they are part from Tshwane, and they are chiefs. They are not here. They are owning the land. They've got the people move about Dulan Libona. What are we saying about those particular people? Why are not part of this today when we want to pass the bill? How can we pass the bill? Meantime, some other people are not here. This is a short notice to us, and we are not supporting this particular bill. Thank you very much.
Greetings to you all, ladies and gentlemen, members of the parliament, the chairperson and the house at large. My name is Happy Manya Taylor from Atteridgeville, representing under Dibouita Tshwane. Land is what we are. Without land, nothing can be practiced. And that is what the Europeans have realized. They know that the PowerPoint is about to be broken. As the result, when we as Black are fighting, that is why this bill is implemented. So I say we reject the bill or whatever. Ne? Land is what we are, and without, okay. Instead, land must be expropriated without compensation for equal use. Because now the government is failing us. We have many properties, we have many lands that is free. And service deliveries has stopped because of this thing of government and what. Service delivery has stopped because parties want to demonstrate, the government want to demonstrate the power of the land. So I say we reject whatever. Thank you.
Ashe.
Sorry, attention. Can we be disciplined? Thank you.
Bobotle ba legislature. Ke tla ke dumedise le bobotle ba duli ba mo Gauteng Tshwane. Wa bona ke nna Happy Mdunana ke tswa ke le Atteridgeville Ward 71. Ke mo ka independent community civic organization. Na ke na lova thata a ke tsore ke tlo thoma ka point number 1. Can you understand that when we talk about land, because there is a place in Cape Town, call it Orania. But and if re sa lokise that place out Orania, that means South Africa or no yang. Ntatola wa liburu o la ki tsoro o bolela eng because tshwantse go thoma kwa go Cape Town a lokise bothata bol and we have to change our constitution. Our constitution it doesn't support any citizen of South Africa. It supports the richest people. Ka rona ra ba ritse re tenela makeisheneng a rena selo. Sa bobedi ke na go tlhalosa taba e nngwe ash. Ko Atteridgeville kwa ona le batho ba lore a bana di title deed but ba ka mara di RDP until 2023 now. Ya diputsi sore where are we going? Ka government e beana. And ona le batho ba ban since ba ngwadisa dintlo 1996 even today batho ba they are still in informal settlement. Ya mafello e ke kopelang batho ba legislature kopela mo country ya rena o formalize the informal settlement tsa rona. Ke a leboha batho ba rena.
Thank you very much. I think first and foremost, I would like to thank this particular opportunity that the legislature has brought in the city to ensure a public view. Because, you know, time and again, you will be just surprised things happening in South Africa without a clear public engagement. But I think with this, I also want to put across that there was a speaker who actually mentioned that there must be a follow-up in terms of this particular engagement. It must not be a once-off thing, and you come hear our views, and post-hearing our views, not even implementing them, or implementing them without even coming to review them again. In most cases, most speakers that have came before managed to put across the importance of rejecting this bill. My position is also rejecting this bill, and we're not rejecting it under the terms that we're supporting DA or AfriForum. There are many reasons at stake why we are doing so. Constitution number 1. The constitution in itself needs to be amended, in particular section 25. Because you would understand why sometime we're literally some of the people are not understanding the constitution itself. Because if we are going to say that we are going to adopt this bill with the very same way the constitution is being structured and that in that particular clause, we're going to find ourselves in tatters as a country. And the agenda of transformation revolves around land reform as well. And in us transforming, it doesn't precisely mean that we're going to abandon the land that is not useful. Hence, we are saying land without expropriation of land without compensation. Why are we expropriating it from the bottom line? It's because it's in the hands of the people that have stolen it from us. And redistributing it doesn't mean that we're redistributing it to use it unnecessarily so, but fruitfully so, with everyone in the picture as well. In particular, black people, because it was stolen. And why do we compensate back when we know primarily that it was stolen? How do you compensate something that was stolen? It doesn't even make sense. And you would find that in Tshwane, where DA is in governance, we know, and it's happening, where they sell majority of the land to the white people. And in that case, we find ourselves, even black people, not even that particular opportunity. You want the mic? You want the mic?
Hello, sorry.
And the sooner the amendment of...
My brother, please do not speak of politics, speak on the bill, because of, and Everyone who follows, can they speak on the bill? Thank you.
As I proceed, we can never, it's fine. Let me proceed and put my points across because we're going to be disturbed here. The sooner the amendment of that clause in the Constitution, we're going to have, there's going to be even a clear constitutional order in South Africa. From the international constitution, that is in line with the rights and that everyone have the right to be entitled to property as well. So along those lines, if we amend the constitution, the bill will definitely work fruitfully and in support of everyone. Thank you very much.
Stage 5. Greetings to the house at large. Greetings to you all. I go by the name of Unosipho Wagantombela. A TUT student from Ward 60, a student and a student leader. Tina, we are here in the legislature now because we've been invited from a campus. So we arrived late, but I managed to grasp some of the things that those have been spoken about. Number one, the expropriation of land without compensation is what we support, Tina, not the one with compensation. Because number one, when is compensation for the is keeping mal. Who are you actually going to pay? Who are you compensating? Who are we giving the money to? We're not going to be compensated when they are going to be compensated. Meaning, how can we compensate for the land that was stolen from our forefathers? I mean, Kulumela, the side of the youth, as I'm from the ANC Youth League, that the land was stolen from our forefathers. It was not actually stolen, it was taken by force. Some of our forefathers and the people who were with them, they died in that struggle. So Tina, we must compensate those people who made us to suffer as we are here as a country today, suffering from load shedding, inflation and unemployment. Those people are the ones who are owning businesses. Njengoba sithi imisebenzi ayikho vele because abafuni ukuthi ibe khona. If abafuni ukuthi ibe khona, there would be jobs because I mean they will be managing ukhetha a space for everyone. Going back to the thing of land, when they bring back the people's land, I mean like bakhona abantu who are able to do things. Futhi kahle kahle, black people are the most assertive people la emhlabeni because whites can't do anything by themselves. All they know, bazofika, bazothatha, bathathe, and then basebenzise the white monopoly and the system. And then abazali bethu bavuka every day baye emisebenzini basebenze kanzima, and then bazobuye bahole imali encane bese the next thing igrocery iyakhuphuka. So ukuthi thina we are continuing nge-apartheid the angazi the new is the new one because leyakudala ngisho bekuyiviva namatoyitoyi. Sho ukuthi thina we are not literally free as yet. So when we're going to sizozama uku-amenda i-legislation ngeke izisebenze because the legislation is bounded by the constitution. I-constitution le eyenziwa ngaboma 1913 which has been claimed to be amended izofana nokuthi cela ukenza example, just an example. iBhayibheli ikhona iNew Testament, Old Testament, part 1, part 2. Ne-constitution bayenza kanjalo, not ukuthi bazoyiqalela from scratch. They need to go back to their drawing boards, bayiqalele kahle from scratch, bazokhona ukuyenza ama-rules, nama-rights, nama-regulations, which are going to be fair on everyone, so that wonke umuntu azokhona ukubenefits, especially the black people. I mean, I'm speaking especially for the black majority, because I mean, this is our land. We cannot be suffering from like this when this is our own land. We cannot be working like slaves in our own land, like we are literally slaves. I would pass slaves. 8 to 5, 3,000. After 30 days, it's only 7,000. It doesn't make any sense. So, Tina, we are saying the compensation land yona is angeke izukhona ukuyenzakala unless kumele kube ne-episode 2 apartheid angisho thina besingekho nasi siqale sitoyitoyi ke once bane kuliwe once. So we are here about the transformation eyabantu. Like we can't be treated as abantu abadala, like abo mama bethu nabo gogo bethu kunguthi siyintsha. We're supposed to take the country forward. Everything that is going on literally does not favor us as the youth. It does not favor us. Amalo shading is everything. Like everything is literally a mess. I don't know how can the government, Maramazwisi government is also that is because I believe Usi government is us. So we should see how can we fix that situation that we are in right now. We should provide our solutions. Ugusi says because let me tell you, Fungusi compensates. Maria Natale Eastern Cape EMs yonke abayisebenzisi. It's just standing there, but it's private properties, okay? Private properties because we join Chile, we join our constitution, we protect amendments in legislation because the constitution is still protecting them. That's why Bazofuna Ama reviewers making us feel like we are important in some of a way. Where else we are not, we're actually out of the picture. So I believe Ugusi we should be also heard and we should be also so that we can also make Israelis who go in South Africa arise to live in. It can't be there. See, Emma township who abantu by 5,000, but Mozo ya le Emma suburbs ni umlungu shange double story nga akamajari 15 when I'm a solution. It's what happened because basase abazali bethu kulelende bafuna ukuthi bababhadalele yona babakhipha bonke babayisa emalokishini. That's why abantu abamnyama sihleli sonke emalokishini siclouded isibaningi. It's because basikhiphe kulelende empty manje basisa emalokishini and then they want us to come back and amend the law. But let's say abantu abase legislation, Gauteng legislature, those about amending whatever. I'm not going to talk about clauses because our clauses now are a systematic thing. I'm still protecting them. So in legislation, you can ama clause wakhona nje siya rejects. South Africa needs to go back to the drawing board. Baqale kahle and plan things that will work. We are going towards a revolution and the NTR. Manje ikhasi zashintsha, yonke into iyachinja. We are no longer than like before. Okay, I close.
Greetings to everyone, chairperson of the session. Greetings to the legislature. My name is Hlamalani Queen Chauke. Allow me to pass the greetings to all those who took their times in this winter so that they can participate in this program. In particular, community members. Chairperson, I think all of us, we are aware of the submission to all government wings and different structure by the governments. By EFF in terms of mode to use an expropriation of South African land. Sitting here, I can only put emphasis on what has already been submitted that must expropriation without compensation for equal distribution. In process, we allow the state to be custodian of the land. As EFF, we are guided by the natural wisdom that none of black and white were born with autonomous control over land and exclusive of others. While we agree the land is a common resource which every one of us qualified to have a piece which everyone qualified to have a piece by more voucher in being alive. I thank you.
Sanmonan, unonhlanhlamnisi lona, mina ngizala ngala kuzokhuluma izinto eziningi. I support the bill, but I would like to register that this bill should be expropriation of land without compensation for equal redistribution. Bafikile lana ngale inkatha bafike ngazo bo 16 banban. They stole from us. And now they want to be compensated. Compensate wanjani ungitshontshele. They gave themselves some hectares and hectares. Tina basinika zama 20 by 20. Then they come and tell us which we must compensate them. As the EFF in closing city, expropriation of land without compensation. Yabo.
Dumela. Nna lebitso ke Class wa Gashawangu ke tswa ke le Winterfeld. Re rata go nesetsa pula or go supporta bill e ya ka jeno re le baahi ba Winterfeld. Re le baahi ba Winterfeld committee re batla lefatshe because of Winterfeld is privately owned and the plot owner tsotlhe tsa Winterfeld a di nne ko Winterfeld. Really baahi ba Winterfeld re nya go enjoy dilo tse di enjoy ke baahi ba di pleke tse di re nya go bana le di internal roads go Winterfeld re nya go bana le di sewer go Winterfeld re nya go bana le metsi go Winterfeld ke lo tse re snang tsona go Winterfeld a re na le proof of residence re le baahi ba Winterfeld. I've heard people that are saying Winterfeld 1 2 3 4 because of they're not staying there mara nna ke le moahi wa Winterfeld ke nna go teng ke a itse re ho bima byang go Winterfeld. So we are saying Renesetsa pula bili hore ka thoma pele ko Winterfeld ra khona re le baahi ba Winterfeld ra kra lefatshe re le baahi ba Winterfeld ka leboga.
Thank you very much, Chairperson, and everyone who's here. I think the issue of land. By now, we were supposed to be in a position where, as a country, we have came back to our senses to an extent that we are going to expropriate it without compensation. I think we support, as the youth of South Africa, we do support that the land must be expropriated without compensation. But I wanted to quickly touch maybe one or two issues around the land expropriation. Really, the land brings us means of production. And if we were to say we are expropriating the land, how is it going to affect the means of production? I think we must also account that to the bill that in this process, are we going to maintain means of production? We are going to make sure when we are taking such a land from someone who was giving production, are we going to maintain that moving forward? So I wanted us to quickly make sure that within the bill, we do mind that as we are moving with land expropriation and everything, there's no poverty. As latter speakers alluded that we're worried of job loss, we're worried of poverty, that this thing is going to bring that. We do have that worry, and it's acceptable that we should be worried like that, because this process of expropriating is going to deal really with the economy, is going to deal with the production, And how do we then maintain that? Amandla. Yeah, so in closing, Chair, we do welcome the electricity back. Yeah, in closing, Chairperson of the session, we really as young people hoping that you are going to mind the issue of production while we are expropriating the land. Thank you.
Thank you very much. We welcome all submissions, and trust us, we are going back to the legislature to speak on the matter. It doesn't end here. It's a fight that we are willing to fight to satisfy the residents of Gauteng. And furthermore, we even heard when you spoke about us to extend the invite to the Human Settlement and Department.
E for Busi, A, L for love, A, L for love, A, at gpl.gov.za. Okay. Bakhona beze nesibhaliwe ama presentations. If nize nawo ngawahanda in. If anizange buyele nemuva no kuluma. Thank you. The meeting's adjourned.